Today. I think this is the second or third time that we've done this particular session, which is managing wills as part one and estate and probate awareness as part two. So I will split it into those two sections. As you can imagine, I kind of say this every time, these are complex issues, and with only 45 minutes to allow some time for questions, we can only provide an overview, but hopefully if there are any particular issues that come up or that apply to you, we can deal with them at the end. Just before I start the main section, I just wanted to say, because this is a legal focused session, I just wanted to reiterate, because I do it every time, the importance of LPAs. I'm hoping this is all news to you and you've already done it, got it sorted out, but just a quick reminder that before we get to the will and the estate situation is to make sure that people are aware of the importance of power of attorney, because it is the only legal way to provide authority to act on somebody's behalf during their lifetime. And important that you have a look at that, particularly that there are two types to consider: property and affairs to deal with the finances of the individual, and health and welfare to deal with matters relating to care home admissions, medical treatments and the like. And just a reminder, because it does keep cropping up, that neither of these documents can be used until they have been registered with the Office of the Public Guardian, which is taking still 20 weeks to get through, so it's a long wait. But in my opinion, vital that we all do it, because the alternative is a deputyship order, which we would really all want to avoid. So I mention that because if you're here on this session and it's either from an individual or from a professional point of view, it's important that we get the bit right before we come to wills and eventually the management of the estate. So that bit aside, and we do the full session on LPAs, which we've done with Carers Sub for the last year, which have been very popular and well attended. So if you need any more information on that, perhaps you could look that up. So coming back to wills, what do we need to understand about wills? And I make the point here that this is particularly in the context of being a carer or caring for somebody's affairs. So basically, as you probably know, it sets out your wishes for the distribution of your asset on death. If you do not have a will, which I was horrified to read an article last week that 60% of the population do not have a current valid will, then the rules of intestacy will apply. And that didn't really used to be a big problem, because in most instances, the bulk of the money went to your direct family. But that has now become more complex. The rules state that if you're married or in a civil partnership and you die without a will, then your spouse or partner will receive all your personal possessions and the first £322,000 of your estate. The balance is then split equally between your spouse or civil partner, with the rest going to children, and if there are no children, on to other family members. So the bit that causes the problem is the fact we live in a world where we have complex relationships, multiple marriages, divorces, stepchildren, all sorts of things that can make that process far too rigid and not what the individual would require. So the simple solution to avoid all of that difficulty is to get yourself and have a valid will, so that you can dictate and direct exactly what should happen. And in order to produce a will, you only have to satisfy three requirements. One, you must be over 18. Two, you must be of a sound mind, which is always the slightly questionable bit. And the third one is that you must make it voluntarily. In other words, there can be no coercion, arm twisting, and you would be surprised how many families go to a solicitor on their own to say, Mum's asked me to update her will. And of course, Mum isn't there or party to the conversation. So that's what they mean by it being voluntary. The issue of sound mind, I raise because it is probably the most contentious part of a will. What does sound mind mean? It basically means that you must have the capacity to understand what you're doing. And I think we make a mistake generally that we view capacity as being a singular entity, that we have the capacity, full stop. The reality is you've got to consider capacity in the context of the decision you've got to make. So if you were looking at, do you have the capacity to decide what you would like for your lunch? That's not the same as do you have the capacity to understand what provisions your will would make. So capacity is dependent on the decision to be taken. And in most cases, where there is a questionable lack of capacity, it tends not to be absolute. In other words, you could have a good day, you could have a bad day, you could have a good time of day. I meet lots of elderly people who are far better in the morning when they've had a good night's sleep and had their medication than they are by 4 o'clock. So you could have questionable capacity in the afternoon, but not in the morning. So a good solicitor or somebody helping you to set up a will, or indeed a power of attorney, where the capacity issue is so crucial, should be willing to find the good day. And I've seen lots of examples where attorneys or an attorneyship has been set up after 6 visits. The first 6 occasions, capacity wasn't there, but on the 7th, it was. And it might have disappeared the second the person leaves the room. You don't have to retain the capacity. You just have to understand it at that time. So that is an important qualification, particularly if you've got elderly family or relatives who haven't set up a will. You're now trying to encourage them to do so, and they may have dementia or any other sort of cognitive impairment that may restrict. A couple of the simple things you have to bear in mind: it must be made in writing. There are provisions for wills to be established verbally, but that's beyond really the scope of today. And secondly, it must be signed in the presence of 2 witnesses, both of whom should be over 18. And most importantly, should not be named in the will. They shouldn't be the executors, the beneficiaries. Ideally, they should have nothing to do with it. And it is important to understand that the witness is doing nothing more than witnessing the signature of the person that's making the will. They're not reading it, they're not approving it, they're doing nothing other than to say, on this day, I saw Charlie sign this document, which was his last will and testament. So 2 witnesses to really just provide added protection, and they must sign it in the presence of the person who wrote the will and at the time that they signed it. So the date should be the same. And really, that's it. Who can you use to get your will done? I'll mention 3 possibilities. One, solicitor would be the obvious one. People find that a little bit difficult sometimes, a little bit sort of, you've got to go into their office. It's all very formal. People find that a little difficult. Also, when you get them back, they can invariably be difficult to understand because these things are written in language that really doesn't help. You can, as an alternative to that, perhaps go to a will writer. There are various of them about. They tend to be a little more friendly. They tend to be willing to come and see you in your home, which can help. They tend to be a little bit cheaper. But I don't generally think there's any loss of quality or value from them. And the third option is you can go to WH Smith's or the post office and buy a standard template off the shelf that you can complete yourself. If your will is very, very simple, I think that's fine. But the minute you get any complexity, then perhaps that's not such a good idea. And you will occasionally, I think it's October usually, they have a kind of free wills month. So if you can wait that long, it might be worth having a look at that. These are run by the charities who basically team up with local solicitors, offer a free will writing service, kind of in the hope that you might, in return, leave a bequest to their particular charity. And again, I would say ideal if your requirements are simple, but not if you've got any complications. So, in terms of thinking about complications, what should the will state? What should it state in terms of covering all issues? Well, I've kind of written three things that should be there. One, it must legally revoke any previous wills, so there can be no confusion about which one is valid. Second statutory requirement is it must appoint executors, which is the posh name for people who you choose to administer your will and your estate. It can be family, friends. I would just suggest take care about appointing a solicitor to be your executor, because that is kind of writing a blank check for them to charge for their services. My preference is appoint family and friends, and if they need help, they can go and get the help from a solicitor. They're not automatically enshrined in the will. So I'm always a little bit suspicious about wills that appoint solicitors, unless there is just nobody else available. The next sort of line and the next sequence of the will should deal with what are termed specific bequest, which is basically if you want to leave a particular item to a particular person, your gold ring to your granddaughter, £200 to the local church, usually relatively small items, pieces of jewellery, furniture, family heirlooms, that sort of thing, going to particular people. And then the main section of the will, which deals with the residue, usually called the residual clause, basically that details what the rest of the estate, how the rest of the estate is dealt with. So you might typically say the residue is divided equally between my three children. It's usually a good idea then to have a what if clause, which is basically what if the person I've named should die before me. And that might say, I'll leave it to my three children. If any of them should die, then the balance is split between the survivors, or you might say their share would go on to their children. So whatever provision you want, but that would be a what if clause to deal with any unforeseen eventualities. And usually the final thing is you may choose to include your funeral wishes, although I would suggest that might be dealt with better in a different way. In terms of the pitfalls, things to avoid and watch out for within writing your will in those terms. The main thing is keep it simple. Keep it as straightforward and as simple as you can. I've seen a lot of wills over my career, and some of them are truly unbelievable in their complexity. When you actually sit down and work through what it says across 2 pages, you could have written it in 3 sentences. So you do wonder sometimes whether or not the author is slightly showing off and trying to confuse. I mentioned before about whether your funeral wishes should be in your will. There is a associated document called a letter of wishes, sometimes referred to as a memorandum of wishes. This is a piece of paper that sits alongside the will. And in it, you can write in your own words and in your own language kind of the directions you would like to give to your executors. And this is a great place to put things like funeral wishes. Quite often, the will may either not be found because it might be lodged with your solicitor, or you may just not have time to read it before the funeral. So a letter of wishes can be a side document that deals with things like that, the hymns that you want, the service that you would like, the church that you would like to be at, any bits and pieces like that. So this memorandum of wishes is almost a sort of instruction from the grave, if you like, where you would say to your executor, this is what I would like you to do, not just about the funeral, but about your affairs in general. I'll refer back to that in a moment, if I may, because they're also a good way to make changes to things that happen, just life events that take place. So when we come back to the pitfalls and the mistakes that I see frequently in wills, is I think it's usually a good idea if you can use percentages rather than fixed amounts to determine how you would like your estate to be distributed. And care is a great reason for that. You might write your will in your 70s when you're fit and able, and you might say that you would like £25,000 to go to a particular relative. And at the time when you write that, that 25,000 could be 10% of your estate. But if you then move into care and you have to spend your wealth on meeting your care costs, by the time of your death, that 25,000, which remains unchanged, might now be 90% of your estate. So it's difficult if you have specified actual amounts. You have to keep updating them as your wealth increases or decreases. So much easier if you could just specify a percentage. The other thing that can be useful is to specify classes of beneficiaries rather than specific individuals. So if you said I'd like to leave £20,000 each to my grandchildren, Johnny, Caroline, and Betty. If your family have another grandchild, there will be no provision for them, and you'd have to go back to the solicitor, have your will rewritten to include the additional grandchild. So much easier if you could say, I would like to leave £25,000 to be distributed equally between all my grandchildren that are alive at the time of my death, and then you've covered it and you don't have to go through the expense of rewriting. So those are just two kind of really simple things that you can do to avoid having to review, to avoid the cost of having to rewrite, because we don't really want to keep going back to our wills and having to update them. Now, by far the biggest pitfall, if that's the right word for this, is what I generally term wills that create a concentration of wealth. And this particularly applies to care, and it specifically applies to couples. It's still the most common provision of a will for a married couple is that they each leave their estate to each other and then on to the children in the event of their first death, which is perfectly reasonable, totally understandable, makes good sense. The problem is if the survivor, having inherited the spouse's estate, then needs care, what that will means is that all of the money will be held by the survivor, which means all of it will be available to be charged for funding care needs. So if you think about a simple situation of a house, for example, we'll take a £300,000 house owned by a couple. They each leave their respective shares to each other and then to the children. So husband dies first, wife now owns her £150,000 half of the house, plus the half that she's inherited from her husband, and then she has a care need. And GCC and any other local authority will expect you to spend your £300,000 down to the £23,250 limit before you get any help. The alternative to that would be if you didn't leave your estate to each other, you left them to somebody or something else, and I'll explain what in a moment, so that you don't create this concentration of wealth. What that would mean then is in the same situation, the survivor would have only their share of the house to be used for care, so they'd only have £150,000 of assessable wealth rather than 300, which is an enormous difference in terms of providing an inheritance to the family. What quite often happens is the money is routed so that it can be used to help that person in care, and I'll explain a bit more in a moment. But in order to do this, there is one crucial and vital thing you have to do, and it relates to the way in which your property is owned. I said earlier, most people in this country have mirror wills, and most people own their house jointly, just as you would a bank account. What people don't always appreciate is that any asset that is held jointly can only pass on the death of one party to the other person, regardless of what it says in your will. So if you had a £50,000 joint bank account, husband and wife, and the husband said, I leave my half of the bank account to the children on my death, that provision in his will would not be allowed to take place. The joint ownership rules would override it, and the full £50,000 would now pass to the wife. So my advice is, if you are an older couple and there is a possibility of a care need, keep the amounts of money in joint accounts as little as possible. Now, when it comes to a property, if you also own the property jointly, then exactly the same problem arises. Regardless of what you say in your will, the house will pass from the first person to the second person. So it's important to find out how you own your property, because there are two ways. You can own it jointly, or you can own it as what's called tenants in common, which is a bit fanciful name, really. It just means that instead of owning it jointly, you own half of it each. And because you own half of it each, you are allowed to leave it to somebody other than the co-owner. So you just need to check. It's fairly simple. You can do it through your solicitor, who does a quick search on the land registry to find out how the property is held. If it is held jointly, then you have to go through a process called severing the tenancy, which sounds very dramatic. It isn't. It's a one-page sheet of paper that separates the joint tenancy into a tenants in common. And then once you've done that, you could consider changing your mirror will, where you leave everything to each other, into one where you don't, and therefore you avoid this concentration of wealth that I mentioned earlier. And that can save you literally half the value of the house. Now, if the survivor doesn't need care, then the process is irrelevant and hasn't saved you anything, but you obviously don't know that at the time. So I would always advocate that you should do that as a protection, as a precaution. Now, if you don't leave your house to your spouse, then who do you leave it to? Well, the answer is simply somebody else. The most common answer to that is you leave it to the children. Nothing wrong with that at all. But in your letter of wishes, you might say, look, children, I've left the house, my half of the house, to you, not so that you can sell it and buy yourself a holiday home in Spain, but I want you to keep the money aside and use it to support mum, should she need it, after I've gone. So although the money's not going to your spouse, you're leaving it to the children with this kind of instruction, if you like, to say, I expect you to do the following with this money. Now, I have to make clear, a letter of wishes is not part of the will and is not legally binding. But I've yet to see any beneficiary have the nerve to go against a letter of wishes. Suddenly people think about being haunted and being chastised for what they've done. So there's a sort of, I don't know, empowerment, if you like, that says you better do as I've told or else. So that's a simple way where you can restructure your affairs in terms of your will and make a massive difference to the outcome, how that money might be dealt with and how it might pass through to the next generation. If you're not comfortable about leaving it to your children because they might sell the house and go and buy a holiday home, then you have the option of leaving your share to trust. People think trust can only apply when you've got large amounts of money. That's not true. They can apply for the smallest amounts. And what is a trust? Well, it's nothing more than an alternative to an individual. Think of it as you might do a limited company. It's not your money, it's just a separate entity. But they can work really well because the trust holds the money on behalf of the family. You have to choose people to act as trustees. It can work in all sorts of helpful ways, maybe not something specifically for today, but a good example is, instead of your children receiving their inheritance in absolute terms, which could be £100,000, the trustees might choose to lend it to the children. They still have the £100,000. The loan is made without interest, and it's repayable only if the trustees choose. And the way this works is to help, well, the most common one is divorce. If your son or daughter gets divorced and has been loaned the £100,000 from your will, then your trustees can claim it back before there's any distribution from a divorce point of view. They might decide to give it straight back the next day after that's been dealt with, but it avoids large amounts of money passing outside of the family through. It could be through divorce. It could be because their business ventures failed and the bank's repossessing their assets. I've even seen it used to protect kind of younger grandchildren who might be going to university, might mix with the wrong company, might, I don't know, become addicted to various substances that you wouldn't want them to have the money to be able to spend. And it's just a way of providing a kind of protection for everybody to just feel safer. And we do a session that deals in that in a bit more detail, should that be of interest. But that's the kind of example where your will would not be simple. That isn't something that you could write up with your W.H. Smith template. You would need to get yourself some professional advice. Then really, just to conclude that bit, what should you do when all that's been written? Well, number one, most obviously, keep your will safe. I would either suggest that you lodge it with your solicitor or with your bank, but most importantly, and it seems blindingly obvious, but you'd be surprised how many people don't tell the family where it is, because you don't want them hunting around wondering where that might be. I also suggest sitting down with the family and explaining your wishes. Don't let them find out what's in your will as a shock when the solicitor reads it out to them. Talk to them in advance. Explain what you're doing, why you're doing it, what you expect them to do in some of these difficult areas. As I said, supporting mum if she needs a care need. And the great example would be that she might be funded by the local authority, but you might want her to be in a home that's got a top-up charge of £50 a week. That trust money that's been set aside, the council can't assess it, the family can't spend it, but they can use it to help mum in the way that dad might have wanted, as an example. And the other thing I would say is please review your will regularly, however unpleasant that may be, particularly after significant life events. Deaths would be the obvious one, house moves. I have one story to tell you just to illustrate this point. It was a case I dealt with many years ago in Devon of a chap who his main asset was a property he bought years and years and years ago in Dartmouth. If you've ever been there, he had a property right on the harbour side, which he'd owned for forever. But it was worth it at the time well in excess of £1 million. His cash reserves were about £5,000. And he had two children, a son and a daughter. One lived in Edinburgh, one lived in London. And the truth was, he didn't really like his son. He didn't get on. So in his will, he left his cash to his son and his house to his daughter. He'd appointed a power of attorney, but he appointed his next door neighbour because his kids were basically too far away to be practical. And the attorney came to me and she said, I don't know what to do. Anyway, we discussed the issues. And I said, but you'll need to have sight of the chap's will so that you know what the position is. And she went to his solicitor, who refused to allow her to see it. And he said, it's none of your business. You don't need to know. So she sold the house in order to pay for his care because that was what the local authority required. And unfortunately, the chap died shortly after the house sale was completed. And then the will was opened. And then the reality dawned that now it was £1,005,000 went to the son that he didn't like, and nothing went to the daughter because he no longer owned the house. But I always use that as a salutary lesson to be careful what you wish for. And once you've written it, make sure you've got the provision for it to be updated and changed. And the outcome of that was that the solicitor was sued by the family for refusing to allow the attorney to have sight of the document. So a very messy business if you're not careful. I think it's always a good idea to list your assets to understand what your total estate is, how much is it in real terms, and just to consider the things that can happen if you get it a bit wrong, because it's ever so easy. So lots to think about with wills, and lots to keep your eyes peeled for. So if we move on to the second part, which is post will, basically post death, and the dealing with the estate that then follows. Obviously, the will is the critical document in terms of leading that. But just to be clear about the sequence from the legal point of view. So on death, your power of attorney appointment that you may have made ceases to exist. It just dies with you as an individual, because a power of attorney can only apply during your lifetime. And at that point, the executor takes over, as detailed in the will. Now, it's important to appreciate they could be the same person, could be your children, son, daughter, both of them, but they are now operating in a different capacity. So you will have to go back through the process with the bank of verifying your evidence in your new capacity, which is a pain and very troublesome, but that's typically what happens. And the executors now take over with the task of administering and dealing with the estates. Now, in order to do that, they must first of all obtain a grant of probate. So let's just deal with what a grant of probate is. In some respects, it is a validation of the will. And it's a process undertaken by the courts to say, yes, this will, we accept that it is valid, we accept that it has been correctly constructed, and that there are no obvious challenges or flaws within it. So that's one aspect of what a grant of probate does. The more sinister part of it is that it's also a means to collect any tax that's due, because the courts will not issue a grant of probate until HMRC have checked the account to make sure if there's any money due and payable. So you have to get the tax payment resolved before you get the grant of probate. The other thing that you will find is that the government and the establishment, if you like, will undertake various checks. A typical one is, and I've had this quite recently, where a letter comes back to the executor to say, we note that Mum's estate had £50,000 in national savings premium bonds. We're a bit confused as to why that asset wasn't listed on their application for housing benefit. Please, can you explain? So you actually got the two elements of the system, one of the few places where it actually combines to double check that you haven't been saying telling one side that this is the situation and then telling somebody else in government that it's different. So you do have to be careful that everything's in order. The only time when you don't need probate is when the amounts of money are small and the banks are willing to release the funds without sight of a grant of probate. The amount varies from bank to bank. 5,000, 10,000 will be the typical amounts, but it does differ. You have to bear in mind that the bank's concern is that if they pay out the money to you as the executor or the beneficiary without a grant of probate, and then somebody comes up and says, actually, that will wasn't valid and I'm the beneficiary and you should have given that money to me, the bank is obviously liable. They don't want to put themselves in that position. So they quite often take the exact opposite approach, which is they freeze the account. They won't allow you to touch any of the money until you turn up with that document. The other thing that's a problem for those of you who would have larger estates is that you cannot get the grant of probate until the inheritance tax bill has been paid, and you can't access the money until you've got the grant of probate. So what you have is a vicious circle, which usually means that you have to go and borrow the money from a bank against the security of the estate to pay HMRC in order to release the funds. So it's a little bit messy if there isn't the liquidity to provide for that. And that's particularly a problem if the main asset is a house, which of course in most cases it is. You have 6 months after the date of death to pay the inheritance tax that is due. And if you don't, then interest becomes payable from that point on. Now, there are banks who specialize in providing this funding for the interim period. You can talk to the revenue, but it's just something to be aware of because it's illogical. It's quite unfair. But then you'll find that the whole probate process is extremely unfair. It almost takes advantage of you when you're vulnerable. It is you can easily be having to complete 60 or 70 pages of information to get a grant of probate through. And I don't say that in just complex cases. If you've got any amount of value and other assets, then you can quickly find yourself in that position. So who can actually apply for this thing? Again, the law is not helpful. The law says that there are only 2 people who can apply for a grant of probate. The first one is the executor, in other words, you, the lay person, or a solicitor. And I guess this is something of a carve up for the legal profession because it just provides them with a constant stream of business. It would not be untypical for a solicitor to charge 1.5% of the value of the estate plus VAT plus disbursement. So if I take my calculator, £500,000 estate, an average sized or average value property and some capital, and you would be looking at £6,000 or £7,000 as the cost of getting the probate, even though in a case like that, there may well not be any tax to pay. The third option, which I personally prefer, is where you complete the application as the individual, but you get professional help to do the bits that you need to. That can quite often be a financial advisor who may have helped you in the past because they know what the assets are and where they are and how to fill the forms in. So you might be able to get some help without having to appoint a solicitor in the full sense of the word. So the process is you make the application, all the questions that gives rise to are dealt with, the tax, if it's payable, is paid, and the grant of probate comes out the other end, which is just a embossed piece of paper. And you would then take that to each of the institutions with whom money may have been held, and on that basis, they will then distribute the funds. Now, I'm not going to today deal with inheritance tax because that just is we could be here for a whole afternoon in its own right. But I am just going to mention two particular bits of it that you would need to be aware of from a probate point of view. The first one is that the allowances for inheritance tax are 325,000, commonly referred to as the nil rate band. But in addition to that, and it's relatively recent, is the residential nil rate band, which is currently 175,000. So in theory, an average person would have those 2 allowances, giving them a £500,000 exemption from inheritance tax. And if you are a couple, then you could be looking at £1 million. The problem to bear in mind is that this residential nil rate band is only available for people who A, owned a property at the time they died, and B, passed it to what's generally termed a lineal descendant. A blood relative might be a better description. So somebody who has been unmarried with no children does not get the allowance, which I think is quite unfair. So you've got to make sure that you understand what your liability might be, at least in rough terms, so that you know which route you're going to travel through the probate process. Will there be tax to pay? Will there be allowances to claim? Following on that same issue, most people do, by the way, qualify for the RNRB, because if you've had to sell your property to move into care or to downsize because of a care need, then you can claim this allowance even though you don't own a property at the time you die. So there is a downsizing relief to be claimed, which is broadly speaking equivalent to the same value. And the bit that definitely confuses people is that you can claim that allowance, both of those allowances, in fact, if your spouse or civil partner died before you and didn't use them. And that's particularly odd with the residential nil rate ban. That's only been in existence for 4 or 5 years. If your husband died 20 years ago, long before it was ever even thought of, you can actually still claim his allowance. So it's a bit of a bizarre concept, but it does mean that you can pick up not only your own allowances and some alternatives if you've had to downsize for reasons of care, but also that you can claim these allowances retrospectively. So again, you've got to sit down and try and work out exactly what that position might be. Now, I guess it's a modern day problem, but one of the things that's worth mentioning is quite often the inheritance of money from parents, particularly if it's a larger amount, can create an inheritance tax liability for the child receiving it. So if you own a property and an estate and you paid off your mortgage and you've got a bit of pension savings and you've got £500,000 and you inherit the same amount from your parents, and suddenly you've got £1 million, you're heading to be over the limits. That means your estate would be taxable on your death. And the revenue actually accepts and recognises this. So there is a slightly unusual concept, which is something called a deed of variation. It's just something to be aware of. We're not going to go into detail about it today, but it allows you to go back and rewrite a person's will literally the moment before death. So, for example, if you were in that situation and you didn't want to receive this money, and that might be because of inheritance tax, it might even be because of a fear of a future care need, and you don't want to create this concentration of wealth that I referred to earlier, you could go and change the will and say, no, I'm not the beneficiary of Dad's estate. It's going to be the family trust. And that mechanism will allow you to legitimately, and with the revenue's approval, redirect that money to somebody else without it passing through your hands. So that can be a very significant and important care-related facility, if we could term it that. Which also means that if your parents didn't sever their tenancy of their property and didn't change their mirror wills, you can technically do it after their death. The only reason that's not quite such a good idea is that if the local authority is sharp, they will view that as asset deprivation, because you had that money and you chose to make the variation. Whereas if your parents change their will, it is not something that you've done, if you appreciate the subtlety of that difference. So in sort of bringing that together in terms of where we are, as I say, inheritance tax we've touched on, but you do have to be mindful of that. And particularly given that we're likely to see a change of government this year, we might have a different tax regime. Inheritance tax allowances have remained static now for well in excess of 10 years, despite the fact that property values have gone up. So there is simply a greater number of people getting caught by it than ever was before. So when you find yourself in the situation of being an executor, being responsible for the estate administration of a loved one or a friend, you've got to tread carefully. There are lots of things to think about, but there are also, as I hope we've demonstrated, lots of things that you can do in preparation for that will hopefully create a better situation when the time comes. So I think that's probably enough from me.